speech as talking to somebody, and then writing in terms of duplicating it in the, on paper, pamphleting and the right, and then something like development over time where speech has been interpreted as writings to deal with iPods and all that. Wouldn't it be simple to just say they talked about speech back then, meaning speech?
It would be possible, but not simple. When they spoke of speech and press, I think I'm tempted to say clear, but I won't say that because in truth, it's more subtle than that. They almost certainly, they being the framers, almost certainly had in mind the distinction between utterances, what you're thinking about when you think about speech, and then their propagation in the form of something like a printed word, but it wouldn't have had to be printed. It could be written, something other than print would have sufficed. Indeed, I'm amused by your time frame, but they would even have embraced, I think, within the meaning of the press, things that consisted of nothing more than a handwritten illuminated manuscript. So the Gutenberg press really didn't necessarily change their view. But the problem with viewing it that way is that you then, though you observe the disjunct between speech or press, and that's in the clause, I think you miss the true connection that the framers had in mind. They were thinking about what today we would call expression. And they were thinking about it, of course, in the terms that they understood. Those were the things that they understood. We speak. I think probably they would have thought that singing might have sufficed too if it had occurred to them, but I don't imagine that it really did. But they also imagined that speech could be propagated, published, disseminated, and at that point probably they were thinking about it as the press. Now here's the thing. Some people think, and I suspect that you might yourself, if you were either driven to it or if you found it useful, that there is a First Amendment difference between press and speech. Potter Stewart thought that. I think he's wrong. Potter Stewart said that the press clause, or the press part of the First Amendment, really referred to the institutional press. And so he said the institutional press had rights under the First Amendment that you as an individual speaker do not have. I absolutely denounce that view. I think that bifurcates the two sides of speech and press in ways that are, if you think about it, inexcusable. I don't mean that Potter Stewart didn't think about it, but if you think about it the way you should think about it, which is to say, of course, the way I think about it, then we now, as Portnoy's analyst said, perhaps we are ready to begin. You know, so the problem when you pursue this bifurcated approach, which I'm actually struck by, not the first time I've heard it, but I will say this, it's the most original articulation of it that I've heard from anybody since we published the book. It won't carry you very far because speech and press are both embraced within the kind of expression that makes up an original work of authorship. And the subject of copyright is the original work of authorship. It's not the tangible medium of embodiment. The tangible medium of embodiment is there, I think probably constitutionally, in order to give us a kind of bright line difference between the sort of utterances that were present when Hotchner and Hemingway had their conversation on the beach in Cuba, which was common law copyright if it was anything at all, and the kind of copyright that we can deal with, where though we can never truly see, feel, touch, smell, hear, or otherwise approach the work that's embraced by copyright with any of our senses, still by looking at it indirectly as a kind of reflection of what is embodied in the text, the medium of embodiment, we get some sense of where the boundaries are. Once you begin to collapse the difference that you're trying to set up, I don't think it will work even for you, although you strike me as a very inventive sort, and I'd like to have more time to talk about it with you. But I wouldn't be persuaded, I don't think even Mel Nimmer would be persuaded by that distinction. It's cute, it's simple, it has a certain appeal to it. I know these all sound disparaging. I'm actually sort of, I'm intrigued by it and impressed by it. It won't work when you finish it out, because it's expression that we protect with copyright. It's the speech and press clauses of the First Amendment, but in copyright terms, it's expression. And I think Nimmer was right when he said, when you look at what is protected by the speech and press clauses, it's really what is subject to fixation and therefore subsistence as copyright. It's expression. It's not more, not less. That's what I would say. If you were my student, I'd give you an A+, but I wouldn't agree with you. And I think that's probably where I would end it. I'd love to talk about it with you, so if you want to call me sometime or email back and forth, my email is Lange with an E on the end of it at law.duke.edu, and I would be glad to pursue this further.
Professor Kwall, last year when we had a seminar, I forget the name of the professors who joined us, we talked about the copyright laws within the Jewish society with regard to the 18th century Machzor, and I'm forgetting the name of which Machzor it was. And it seemed to me the outcome of that was whoever had the political power and whoever had the economic, whose ox was being gored was going to control Jewish law at that time within the, at that time there were only Orthodox communities. So within the traditional Torah authorized communities was a moving target. And the outcome was control of the economics. Does that tie in with Professor Lange's discussion of perhaps absolutism as long as the economics are controlled?
That's an excellent. Is this working? That's an excellent. That's an excellent question, and I think that the answer, as a general matter, is that law is always tied into the rent-seeking abilities and the power economics. And so I think the answer to your question, from my perspective at least in that regard, would be yes. In the copyright parlance, a lot of the criticisms of copyright law, especially that appear in the legal scholarship and come from the legal academy, basically mirror that, and they talk about rent seeking and the rent seeking opportunities, and that's what's influenced copyright law. And really, what they're saying, to put it in the context of sociology, if you will, would be that those voices who get access to the discourse get to shape the discourse, right? And I think, and maybe David can talk a little bit more about that even in the context of copyright law, but I think it's clearly there in copyright law. And just to go back to Jewish law for a moment, it's clearly there in Jewish law too. One of the things that I didn't say in my original comments, but that in the entire transmission of the oral law that I talked about, there is apparently only one woman. And that one woman, does anybody know who that one woman is, by the way? Anybody? No, got to go further back than that. It's actually Deborah, who is one of the judges. Okay, and we know that because in the Pirkei Avot, when it talks about the transmission of the law, judges are mentioned. And to as best as we can tell, and I haven't researched this yet in depth, but Deborah was the only female judge. Whether she had Mosaic ordination, I don't know. I want to research that. But I think it's an interesting question, because really what that shows is whoever is allowed access into the discourse obviously is going to shape what the law looks like if you're looking at the law through cultural terms. And I will confess my bias here. I do tend to do that. So I think your question is an excellent one. David, do you want to say a little bit more about the economic balance?
Yeah, I don't think I can do any justice at all to the full question that you asked, but it gives me an opportunity to expound on one part of what we think the consequence of an absolute First Amendment would be. And I do want to make it clear, it may provoke additional dissent and anger. I want to make it clear that the First Amendment as an absolute means that Congress does not have the power, even if it's a good idea, doesn't have the power to enact a law that abridges speech or press, and the two are seen as essentially one for this purpose. Now that means, for example, that something that you are likely to loathe, and that I myself have some misgivings about, namely peer-to-peer file sharing is perfectly open and acceptable under an absolute First Amendment for just the same reason that if Mike Royko wrote a column and you read it and you liked it, you'd be free to do anything with it you wanted to do as far as talking about it is concerned. And to the extent that copyright said, no, you can't do that, that's a copyrighted work, the First Amendment as an absolute would say, well, you know, Royko, it's too bad. He can do anything he wants to with it. It's expression, to be sure, as well as ideas, but that bifurcation, which doesn't really work very well, doesn't prevent him from discussing it in any degree he wants and changing it in any way he likes. That's a big change. That's a huge change in some respects. Though, if you think about it, the consequence of that change, which looks stark to somebody who's accustomed to copyright as we've known it in the past 40 or 50 years, or the last 100 years, it isn't really that stark. The truth of the matter is that's the way the world is now. I asked my students once in a class how many of them downloaded at will, and they all raised their hands. And then I said, how many of you have, I've forgotten what the threshold was, how many of you have in your computers right now, let's say I said 500 works, they laughed. The median number of works that they had in their computers, as I remember, was something like 3,000. And these are law students who understand, well, let me just ask a question here. No, I won't ask the law students here. But the truth is, we're already engaging in peer-to-peer file sharing. I'm not. I want to make it clear, because I haven't the faintest idea how to do it, and frankly, not the faintest interest in doing it. It's enough for me to forward the occasional email. That's about as far as I'm willing to go. But it's already happened, and what's been the consequence? Well, the record industry is angry, and business models have begun to change, but the truth is music hasn't stopped, and as a friend of mine, Burtis Downs, says he wouldn't like this if he knew that I were quoting him, and he would say, you're quoting me out of context, but as Burtis Downs said once in this general area, you know, what are we going to do about peer-to-peer file sharing? I should say Burtis Downs is the general manager of REM. Burtis said, well, I tell the boys, just polish up your live show, because in the end, that may be what you have to do. I mean, and what's wrong with that? That's what the Dead did. The Dead were the most successful rock band in their time as far as revenues are concerned. So economics are not in truth just a square function of exclusivity. Now, that's one side of the consequence. The other side of the consequence is that to the extent that you appropriate something for some commercial use and you actually manage to make money, and you may very well do that. You might be the one, if it were not for copyright, who decided to do Gone with the Wind 2 or something of the sort. You could do it, and what would you owe to the Margaret Mitchell estate and to, who was it, 20th? It must have been 20th, who released that picture. What would you owe? Well, you would owe as much as the value of those appropriations in your work amounted to. That's just standard copyright infringement theory. So that survives. There's no problem, I think, under the First Amendment with that kind of survival. You can appropriate things for commercial purposes, and if you succeed and you actually have net revenues, you can actually keep the net revenues that are attributable to your own effort, but you are obliged to share, or you could be obliged to share them over with the people from whom you appropriated it. Now, what's the significance of that? It's not rent-seeking in the usual sense. It's not a compulsory license. It's not a liability regime in the style of Calabresi and Melamed. This is actually a case in which, if you make money, you can be required to, you could be. Congress, will do what it wants to do, but within the limits of an absolute First Amendment. It might decide not to do anything. But if it wanted to, it could require you to pay over some portion of the net revenues that you actually generate, reflecting the importance in your work and your exploitation of whatever it was you took. Those are the economic consequences, broadly speaking, of an absolute First Amendment.
What about pre-publication restraint, though? I mean, that's a whole different.
You're talking about pre-publication in the Harper and Row sense?
Yeah, or in the qualifying fire in a crowded theater sense also. I mean,
Well, let's put fire in a crowded theater to one side, because that's not actually a copyright-oriented thought. But the Harper and Row sense, the Nation magazine would win hands down, but it would be obliged to pay over to Harper and Row and to Gerald Ford and the agent and so forth as much of the value of that appropriation in its magazine article as the appropriation was worth. And how would we measure that? Well, I won't rehearse it because I know you know it. It's really just standard copyright infringement theory. Nothing more, nothing less. Except that it's profits, it's not damages. There's no damage claim because nothing is in that sense damaged. Does that make sense? I don't mean do you agree with it, but is it? Yeah, it makes sense. Yeah. Yeah.
Could you have replaced, if the founders had taken away the copyright clause, could they have inserted and kept the absolutism of the First Amendment? Could they have inserted a commercial contract clause?
In the Bill of Rights somewhere, you mean?
Yeah, I don't mean in terms of actually writing in, but the concept that your speech and your press, you can contractually limit, so that the first, in effect, publisher, in effect, has a license clause in there that says, I'm willing to sell you my 10 newspapers if you don't resell those 10 articles, and that person doesn't resell it. And then you come back down in a certain sense to the peer-to-peer issue.
Could they have done that in 1791, in other words?
Well, I mean, is that make a good theory in terms of saying we'll eliminate the copyright clause, but we'll allow contracting? I mean, because that's what we do with software. It's all licensed.
Yeah, the problem is, well, I was going to say there are three kinds of contracts, but if you take software shrink wrap licensing, you can even think about it as four. You've got a true contract which may be express or implied in fact. Both of them I regard as true contracts, and because of your question, my guess is you do too. There is nothing about an absolute First Amendment that prevents you from continuing to observe and defend true contracts. You can waive, in effect, your First Amendment rights in favor of a contract that's more specific, with or without any change in the First Amendment. The problem begins when you talk about a contract implied in law, or a quasi-contract. There you can't really recognize that kind of contract because that's not much more than just a proposition of law, and you can't, distill old wine in new bottles and get away with it. So you'd need something in the First Amendment in order to make an implied in law contract work. Shrink wrap licensing, in my view, is wrong for a different reason. It's basically an adhesion contract that shouldn't be upheld in any circumstance in which there really isn't a true bargain. If you read, and I know you will have done this, if you think about Frank Easterbrook's opinion in, what the hell case was that? I'm sorry, I shouldn't be swearing in at least a partly religious gathering. You know the case I'm talking about in which Easterbrook upheld a shrink wrap license?
Pro-CD? Pro-CD? Pro-CD?
Yeah, Pro-CD, exactly, the Pro-CD case. I think he's just dead wrong because that really wasn't a true contract. Shrink wrap licensing may or may not be a true contract. You could have something that was. I don't think that was. But there's no reason why you cannot observe true contract theory implied in fact or express and have no conflict with the First Amendment, absolute or otherwise. Does that really respond to your question?
Yeah, I mean, we're saying you could.
You could, yeah.
You could eliminate the contract, the copyright clause, and if the law had developed contract-wise.
You could do that. I myself wouldn't necessarily think that was a great idea. I'd like to keep the copyright clause, but I'd like to understand that the First Amendment is paramount. And where there is a conflict, then the First Amendment has to control. But there are lots of things that Congress is authorized to do, I think, by virtue of the copyright clause that it could keep on doing. Here's one that might not occur to you because it didn't occur to me until I was 3 or 4 years into the writing of this book. Everybody I know, I don't know about you, Bobby, but all of my colleagues at Duke and lots of people besides, not everybody I know, I mean Jane Ginsburg doesn't think this way, but a lot of people think that the DMCA is just bad legislation. I'm not wild about the DMCA as it actually exists, and there's some things about it not, recirculating or disseminating things like the formula for decoding, deconstructing the code. that I think is plainly a violation of the First Amendment. But the basic idea of a DMCA that will be useful to construct a fence within which you can actually exploit a work, I think that's actually defensible under an absolute First Amendment. Why do I think so? Well, for the same reason that I think if you've got a bricks and mortar venue, like the one that the Dead used to play in, or like the place where you go to watch a movie, and you can charge people admission and you can limit what they do once they come inside it, I don't see an important or principled reason why you can't have a DMCA that does that. But the thing is that would be different is if you go to the movie theater, or well, let's just say the movie theater. You go see a movie theater and you watch a movie like This Is It. Not a good example because nobody could take away much that they could use from This Is It. It's just too amazing. I just saw Amelia yesterday, or maybe the day before. You can go see Amelia and you could take away most of what is in Amelia. Things that are good, things that are not so great. You can make any use of it you want, but in the theater itself you could be forbidden to take a photograph or to record that. That's all that I think the DMCA really does. It creates virtual venues. And I think they're perfectly defensible under even an absolute First Amendment. So a lot would survive, and because a lot can survive, I actually would like to see the copyright clause kept in place. But it wouldn't protect against appropriation as such, and some other things as well. Make sense?
We had some questions on this side.
It's a kernel of an idea that I can't articulate particularly well, but I'd like you to speak to it. There's something in this, these two modes of dealing with the law that strikes me about the intent. Of course, you can't see intent, right? Why did the framers put this in there? I'm pretty sure they weren't worried about, as I said, I'm pretty sure. When the divine gave law, whatever, I don't think business was the basic concern. When you're talking about copyright law and infringement, you're really interested in, is this a product? And can we control the product, right? When does expression become a product? And I hear that there's some underlying intention here about, is society always commerce? Is commerce the same thing as society? Right? Does this make any sense?
In the U.S., in the narrative of the U.S., where economic incentive is really the capstone of copyright protection, that makes perfect sense. But if you go to the rest of the world and you look at how the rest of the world looks at copyright law and the kinds of rights that the rest of the world is granting to authors, and now I am talking about moral rights, that doesn't make sense. But we're just looking at it so much from a U.S. focused perspective, which looks at economic incentive as the be-all and end-all for why people create.
I want to, this is a place where Bobby and I probably slightly diverge in what we think. What I would say in answer to your question, which I understand, is that everything she says about the world at large and the natural law basis for copyright elsewhere, I completely agree with, of course. But even here, I would put it to you that our sense that copyright is about commodities and property is probably more mid-late 20th century than it is mid-late 19th century, and more by far than it was early 19th century or the 18th century world of copyright that the framers knew. And the difference, I would say, is that what the framers, I think, were thinking of, to the extent that we can really imagine that they were thinking of anything coherent at all, because there really is, again, no record of any discussion or debate or understanding among the framers at large about this at all. I think that what they wanted to create was something more nearly like an intellectual economy than an economy in the commodity sense. And an intellectual economy might be achieved in any number of ways. A bricks and mortar zero-sum game approach would be one way, but it wouldn't be the only way. In fact, I think, truth to tell, that the absolute First Amendment that Jeff and I have in mind would yield an intellectual economy of a richer and more diverse sort than the zero-sum game, standard commodities-centered economy that we now have come to think copyright is part of. I don't think the framers thought of copyright as involving a product at all. I think they thought of it as involving an enrichment of the discourse. Now, you may say, remembering what I said by way of denouncing Sandra O'Connor, that she had it right then all along, that this was meant by the framers to be the engine that drove the First Amendment. And I would still say that's just bogus history. The framers weren't thinking about the First Amendment when they did whatever they did with the copyright clause. I mean, there's no reason to think that they were, and I think, in fact, they weren't. And when they got to the First Amendment, they weren't necessarily thinking of driving expression. They were actually thinking of disempowering Congress. They were actually thinking of keeping Congress from doing whatever in its wisdom Congress might otherwise have been inclined to do within the limits of the Constitution, under the Commerce Clause or the Copyright Clause or the General Welfare Clause or whatever. I think that the framers wanted to prevent Congress from having the power to abridge speech or press. That might have been seen by some as likely to drive, you know, the engines of expression, but I think for most of them it wouldn't have gotten that far.
Ted?
I'm not an attorney, and I probably know more about Jewish law than I do about U.S. constitutional law. But one of the things that occurs within the Jewish law frequently is a matter of timing. In other words, there are laws which are strict laws, which cover all circumstances, but after a certain period of time, the law becomes a non-law, at least to the extent that somebody who is prohibited to do something can voluntarily say, okay, I want to do it now. Well, within U.S. law, there's a time limit on the copyrights. I mean, it's not forever. You get a copyright for so many years. So how does that impact the note that the absolutist notion that if you have a law, that it's unchangeable?
Do you want to respond to
So
that?
how does that impact the copyright, I should say?
So, some people do look at copyright law as tantamount to forever, because it's a long period of time. Copyright law is the life of the author plus 70 years in most instances. You know, one of the things that David and Jeff talk about in their book very early on, that I sort of give some play to in the piece that I wrote, actually has to do with the Eldred case, which, as some of you may know, is the case in which the United States Supreme Court basically held that the recent Copyright Term Extension Act, which extended copyrights from life of the author plus 50 years to life of the author plus 70 years, was constitutional insofar as that pertained to existing copyrights. And you know, David and Jeff talk about this and say that that decision, okay, perpetuates the very regime of copyright exclusivity that's been allowed to develop in the absence of an absolutist approach to the First Amendment. And I thought that was really interesting because Eldred isn't per se, you know, about how much you can appropriate. It's about the length of time, the duration of time. So I think that your question, you know, sort of made me think about what I thought when I first read that language about Eldred in David's text, and how that would sort of fit into the exclusivity. And I think, for me, interestingly enough, the parallel to that was something else that I discussed in the review, which is I gave the parallel of the 2000, and again, some of you may know about this, some of you may not. In 2006, the lawmaking body of the conservative movement issued an opinion that said, and it was one of several opinions, but in this case it was one of two accepted opinions, meaning it has teeth to it, majority status. And it said that the ordination of gay rabbis is an acceptable choice in Jewish law. Okay, in truth, there were 2 opinions issued, both with the requisite number of votes to get a majority. So now in Jewish law, individual congregational rabbis have the ability to either buy into this or to not buy into it. That's just how the lawmaking works. But the reason I think it's a parallel here is, if you take an absolutist approach to the law, okay, and under David's perspective in terms of the First Amendment / copyright law, an absolutist approach is going to say that what happened in Eldred from a time standpoint, which was your original thought here, Ted, that the regime of exclusivity that it perpetrates and that gave rise to extending the copyright term can't be countenanced in the face of an absolute First Amendment. The parallel that I use for that is if you take not just the text of Leviticus, which says what it says, but also the tradition, the Jewish tradition, it's very hard to end up with a position under an absolutist framework that says that you can do this, that you can ordain gay rabbis. If you take a balancing approach, a Holmesian view of Jewish law, then you end up in a different place. So I thought that sort of was a very good capsule summary of how absolutism sort of works in the real world from the standpoint both of copyright law as well as, in this case, Jewish law. Do you want to add to that, David?
Well, I would say this, but it doesn't at odds with anything Bobby has said. It's a good thing from an absolute First Amendment perspective to think that copyright exclusivity is limited, because if it were unlimited, it would be all the worse. But it's bad whether it runs 99 seconds or 99 years. The average copyright now is reckoned at 95 years. It's bad if you have an exclusive right, because it violates the First Amendment's right, or the First Amendment's proscription against abridging speech or press. In the Pentagon Papers case, which I'm sure you remember, Black said every hour that these newspapers have been under an injunction is an hour in flagrant violation of the First Amendment. And I think he was absolutely right when he said that. An hour, a month, a day, a year, they're all violations. It's just a question of degree. An absolute First Amendment doesn't allow you to balance in that way. A Holmesian First Amendment might, and probably in some circumstances would. I think that's exactly what Bobby is saying from a slightly different perspective.
Here?
I don't know the historical underpinnings of the fair use and parity, other than they just kind of make sense. But if there was some dialogue or debate about the historical underpinnings, that rather than coming up with those as exceptions, should have been visiting a more absolute approach to the First Amendment, if there's something that sheds light on that.
I'm not sure that I'm answering the question that's really in your mind, and that's a sort of a occupational hazard in these exchanges. Nimmer thought that there were 2 reasons why the First Amendment was not violated the First Amendment was not violated by copyright. First, he said, and foremost, the idea-expression dichotomy means that while expression can be, protected against appropriation, ideas are free to be appropriated at any time because copyright doesn't protect them. And that, he said, that idea-expression dichotomy is one reason why copyright doesn't violate the First Amendment. And the other, he actually didn't say this in his article, either of his essays, his speech or the later essay he published in '70 in the UCLA Law Review, as straightforwardly as I'm about to do. But he's been treated since by the Supreme Court as if he had, and so just for the sake of abbreviation, I'm going to do it too. He said, or he suggested, implied, that the fair use doctrine was also a reason not to worry about a violation of the First Amendment in copyright exclusivity, because in all those cases where it was important to allow someone to appropriate expression as well as ideas, we could be expected to do that. Now, he did also say, and it was more than a footnote, that there are some kinds of expression that simply can't be protected by copyright legitimately as against the First Amendment. And I think the thing that was in his mind most of all were the photographs of the My Lai massacre, where he thought that you might have a copyright in that, but it shouldn't protect against a First Amendment, or it would not supersede the First Amendment. Now, putting those things together, what I would say to you is that fair use, at a practical level, at the level at which we practice it, is so erratic in the way it works that no one really has the slightest idea in advance, no sure idea of whether they're within a fair use scope or not. And that's true even if you're a disciple of Pierre Laval. The Laval transformation test doesn't really work clearly. There are dozens of articles, and my guess is you've read them yourself. There is a new body of work that I'll tell you about that you may want to know about. It hasn't been published yet, but it's being spearheaded by Pam Samuelson at Berkeley, who thinks that she can make sense of fair use, but I don't agree. I think she can't. I mean, fair use is just, it's a dog's body of stuff that doesn't add up. And of course, Hand himself said, with respect to the idea-expression dichotomy, he said it numbers of times, but he said it in the Nichols case. He said it in the last case he ever wrote in copyright, which was the Peter Pan case, just not long before he died. He said, no one has ever been able to fix the line between idea and expression in advance, and no one ever can, or ever will. If those things are true, if the fair use doctrine is a mess, and I think any copyright lawyer is likely to agree, at least privately, that it is, unless they've just won a fair use case. It is a mess. And if the idea-expression dichotomy line cannot be fixed in advance by anyone, no one ever has, and no one ever will, as Hand himself, who was its foremost proponent, thought, then I don't think that these are responses, really, to the First Amendment. They are really make-weights. And the thing I haven't said, but it's worth stressing, is I like Mel Nimmer a lot, not just a small amount. I thought he was a very gracious and decent man, and personally very kind to me on the occasions where I asked him questions and had discussions with him. I'm not claiming mentorship or anything, but somebody I really admired. But in constructing the idea-expression dichotomy, and to the extent that he did, the fair use doctrine in response to the First Amendment, it has not escaped my notice, nor has it escaped the notice of other people who've written about it, that copyright wins everything and the First Amendment gets nothing. I mean, the First Amendment is great just as long as you understand it's copyright like turtles all the way down. And when you've got a compromise of that kind, I think you have to have some doubt about whether that's really a compromise, or whether what you're really doing is just preferring one doctrine based on one set of theories to another. And that's what I actually think he did. Now that may be unfair to him, and he's not, of course, here to defend himself. In this respect, he was a great scholar of the copyright law. But he was also a serious scholar of the First Amendment as well, and he had a treatise in both. And so I don't want to make it sound as if he didn't know what he was talking about. I just think that he once himself observed, with respect, I think, to Judge Gerfine in one of the cases just before the '76 Act took effect, in which Judge Gerfine wrote an opinion that was at odds with what became Stewart versus Aben. Mel was commenting on the judge's error, and he said, well, like Homer, he nodded. And I think that Mel nodded when he wrote that essay on those distinctions. Great scholar, and a great man, and a fine person. But I don't see how you can posit those two doctrines, both of them internal to copyright, as an adequate response to the First Amendment.
Question? A little bit about.
Yeah. Regarding, you mentioned the originalist versus an absolutist. I'd like to hear your comments on both from the Jewish law perspective and copyright. What effect would it have on an originalist reading versus just an absolutist reading of the copyright law and First Amendment? And then Professor Kwall, the same thing with an Orthodox reading of Jewish law. originalist versus an absolute, because it seems as though in Jewish law, they're one and the same from an Orthodox reading. And, you know, I'd like to hear both from a copyright perspective as well as Jewish law.
You want me to go first?
Either way, go ahead.
Well, an originalist, I think, is someone who takes the text of the Constitution, in this case, and tries to understand what it was that the framers themselves thought about it at that moment in time. And then that becomes the idée fixe against which everything is subsequently measured. It's akin to what I understand Bobby to be saying to be the difference between the Torah and the Talmud. And an originalist would tell you it's just the text and what the framers thought the text meant. You may want something else, but if you want something else, they told you how to get it. They said you can amend the Constitution. The approach to the First Amendment that we think is correct, it brings you to an absolute position, is closer, and again, I now understand, I think, what Bobby's saying. It's closer to what she describes when you understand the text to be fixed, but subject to elaboration. What you're elaborating is still, however, the text, and you will elaborate the text in order to apply it to something like the DMCA, which, of course, the framers would never possibly, could not possibly have thought about. It's still the text which controls. Now, that's how I would explain it from a copyright perspective.
And I would agree, and so just to flesh it out a little bit in the context of Jewish law, you know, what I said during my remarks is that Judaism is not a religion of fundamentalism, meaning you just look at the text of, let's say, the written Torah. So remember the example about eye for an eye. If you look at the text of the written Torah, it seems like it's suggesting that physical exactment is appropriate. But because, and that might be consistent with what some people would say is originalism, this is what the text says. But in truth, what the classical tradition espouses is more of an absolutist approach in that you're not just looking at the text. The text of the written Torah has never had a fixed, determinate meaning. The text has always been, from its inception, debated and discussed. Remember, the oral law was transmitted orally for centuries prior to it being redacted first in 200 with the Mishnah and then 500 with the Babylonian Talmud. And so what had developed there was this tradition of interpretation. And when I use the term absolutism to refer to, as I use the term, an orthodox approach in the text, but I needed to just clarify something about that too. Orthodoxy, as we use that term today, that's something that basically started, you know, in basically the 1900s. I mean, there was the classical tradition, and then when Reform Judaism started emerging in Germany, particularly in the 1800s, excuse me, not the 1900s, Orthodoxy, as we know it today, was a response. But before that, there was just the classical tradition. So what I'm saying is the classical tradition is absolutist in the sense that it looks to the text, but it looks to how the text has been interpreted through the Talmud and then through classic commentary. That's absolutism. What absolutism isn't going to do is say, okay, in lawmaking, as opposed to law application, it's okay to take into account sociology, economics, demographics, archaeology, linguistics. That's not within the scope of how an absolutist approach to Jewish law works. That is in the scope of how a historical approach to Jewish law works.
Imagine the scenario that Moses has finished 40 days up on Mount Sinai. It's just about to come down with the luchot, the stones, and the last thing he does is put a circle C in the corner.
Right.
I'm sitting here just, you know, trying to think of what's going on here, and the difference in philosophy that Judaism has to law and what secular law does. We see it in many, many ways. We have the, you know, the amendment says the power that's not actually given to the government remains with the people, which is absolutely contrary to the Jewish point of view that The earth is the Lord's in its fullness, the seas and everything in them. Everything emanates from God, and God gives the rights to things. One might ask, in terms of creative property, does that have any effect in the debate between how Judaism would apply not just copyright law, but any creative intellectual property ideas as opposed to secular law? I made it, I have the right to it. Whereas you can't imagine the 5 books of Moses, Moses coming down and saying, I'll sell this to each one of you. I mean, I spent time on this.
I'll answer your question. I'll take a stab at it, and then I'd like to hear what David has to say. You know, I'm not an expert on Jewish copyright law. David Nimmer, who is Mel Nimmer's son, and Neil Netanel, as I mentioned earlier when I talked about former JLJS programs, are actually writing a book on Jewish copyright law. And you heard their presentation a year ago when they were here. But I will tell you, I will suggest to you that I think the origins of moral rights comes very definitely from the Genesis narratives, and particularly from the Genesis narrative involving Adam and Eve. Okay, so I will tell you a little bit about that, because I think you can very much use Jewish law as the basis of authority for moral rights. So what the text of the Torah says is that the serpent was trying to induce Eve to eat the apple, and as God had said to Adam prior to that, do not touch the fruit. Do not touch the fruit of the tree. He said, do not eat the fruit of the tree. Do not eat the fruit of the tree. God didn't say anything to Adam about touching it. He said, just do not eat it. Okay. Adam then repeated those instructions to Eve. Okay, but Adam said, do not eat the fruit, and do not touch the fruit. Okay, and according to a midrash, which is basically a midrash is viewed as sort of a literary explanation of the Torah that's been developed by the rabbis through the generations. According to the midrash on this, what happened is that the serpent pushed Eve against the tree, and so she touched the fruit. And the serpent said, you touch the fruit, nothing happened, you can go ahead and eat it. And the midrash says, because of that, Eve ate it, and we all know that the rest is history. Well, what's going on there, as I argue in a different work that's coming out, is a violation of moral rights. Because God was very clear in his instructions. He said, don't eat the fruit. That's what God said. But then when Adam said to Eve the instructions, he changed them. He mutilated them. He said, don't eat it and don't touch it. And he failed to attribute authorship of the original verbiage to God. So as a result of a moral rights violation, I am suggesting we really have the basis for an author's proprietary interest, which we have very clearly in the Jewish tradition. And I think if you also look at other aspects of the Genesis narrative, you can find a lot of support for the fact that for how authors create and why they should have the ability to at least preserve how their work, that people know how their work was originally conceived. So I guess my answer to your question is, in the Jewish tradition, you have a very strong basis for authors' proprietary interests, notwithstanding the fact that everything, there's stewardship and everything comes from God. Because while you're in possession of your gift, your creative gift, you have a responsibility to make sure it gets appropriately demonstrated, appropriately displayed. Okay, David?
Well, I don't know that I'm competent to respond to your question, because I really can't comment in the way that Bobby can on Moses' communion with God, if you can even call it that. But and not to duck it, I mean, I have some thoughts about it. I guess I'll give you my incompetent thought, but I really want to move on to a slightly different response about which I feel more sure of myself. I think there's a great deal of difference between authorship attributable to God and authorship attributable to Disney. So I don't know what I might think if I believed in my own world that the 5 books were authored by God. I don't dispute it. I just simply, it's not a belief that I can truthfully say that I subscribe to in the same way that Bobby does and that I respect. But if I did, I think I might have any number of thoughts about the meaning of copyright if it was claimed by God. I suspect I wouldn't have written this book in the same way, or at least it would have had another part. Now, one thing we do know, though, is that when you copyright laws in a secular sense, the consequence is often really very distasteful and baleful. I mean, we see this in cases in which individual lawyers copyright contracts and tax agreements and so forth that then cannot be used without at least a license by someone, even though they may really have been accepted in one case by the IRS and may be really the only legitimate way in which you can actually put this deal together, because anything else may stray from what the IRS. That's only an example of how things go awry when you claim copyright in law. I don't think that lawgivers ordinarily would wish their laws to be copyrighted in that way, and I don't mean this in any sacrilegious or blasphemous or disrespectful way, but I think probably God didn't intend to copyright the laws himself. I think God meant for the laws to be followed. God is different from us in this respect, it seems to me. When God speaks, it's a performative act. That isn't true for any of us. So God doesn't actually have to have a copyright in order to protect what he wants to do. I mean, does that make sense to you? I mean, God is.
Take it much more seriously than I did. I mean,
Yeah.
that's-
Well, I mean,
just
seems.
Put God aside for a second. Moses is the one that comes on. I'm thinking about if the idea is that even creative process is transcended for whatever reason, a force. Is there a different perspective of that the creative idea you have does not emanate from you and you don't own it, may be a component of how one set of philosophies looks at what presumptions they bring to the table as opposed to another.
Yeah.
That also
I
goes
wasn't
to
trying
the,
be deist about it.
that goes to the issue. I see that as going to the issue of why people create. Okay, and whether you call that transcendent force God or a power from above or something that's propelling the creative process, to me, what that suggests is you have to have a legal system that takes into account more than economic incentives. But I also want to just clarify one thing about Jewish law, because I don't want to leave a misimpression about that. Jewish law, and I hope that this was somewhat clear from my comments, Jewish law has always been, even though the origins are divine, under any theory of Jewish law, God dictated, even if you say God dictated to Moses. But Jewish law as it exists today is the product of cultural human creativity. It was creativity in interpreting the written Torah. It's human creativity in applying it. It's human. Now, what that spells in terms of copyright implications, I completely agree with David. You can't talk about monopolizing or copywriting or privatizing the laws for the reasons that David explained. But I do think it's important to understand that even though there's the vertical, the divine anchor to Jewish law, the system as it's evolved is very much a system that is a product of human judgment as to what God's will is. And that's true really for the classical tradition, as well as certainly for the historical viewpoint. Okay, I think we have time for maybe one more question.
I submit to you that by the mere act of comparing Jewish law with the absoluteness of the Torah and just the eye for an eye clause or the other clauses of if you disrespect your parents, you're to be stoned to death. If you violate the Sabbath, you're to be stoned to death. By the mere fact that there is an oral law that takes those strict laws and interprets them, if you're going to compare the absolutism of the First Amendment to that, you have to then take the position that there can be no absolute law that is applicable over a time period because because of how society changes. I mean, to stone to death a child back when the Jews were wandering through the desert, I'm sure it didn't happen, but might have been, maybe beat him up a little bit, might have been more appropriate at that time. It's certainly not now, and so obviously things have changed over time. And I submit to you that any law that's 300 years old, perhaps maybe not murder or something like that, but any law like that has to be used to be interpreted somehow for two reasons. One, we would all be out of jobs. And two, I just think it's you would have no right of privacy. You would have all these things that you have. You have, I was just thinking some of the other income tax laws are clearly unconstitutional if you take an absolute reading of the Constitution. And so you can't. I understand it's a whole philosophical position on that, but again, I submit that by merely comparing the two, you can't then take the position that the First Amendment is absolute without an interpretation.
Well, I would respond to you by saying that I submit that the income tax laws were regarded as unconstitutional, and so we passed an amendment to the Constitution in order to make them constitutional. And I submit to you that there is nothing that is on the face of it unconstitutional or really out of sync or out of keeping with the world that we live in today in the concept of an absolute First Amendment. It's unaccustomed, to be sure, but there's nothing about it that would radically change your life in any serious way. You say, because I think you imagine that the right of privacy, and let's think about it in terms of Roe against Wade, is an artifact of a more moderate First Amendment, but that doesn't necessarily follow. There's nothing inconsistent with recognizing an absolute First Amendment of the kind that I'm talking about, and that Jeff and I have proposed in this book, and understanding in just the way that you propose, and just the way that I understand Bobby to suggest that the Torah is elaborated upon by the Talmud. Just so, the First Amendment remains the text, but it has been elaborated by experience. What it cannot do, however, is be tortured into submission in order to serve the things that we prize in our time. That's my view, and when we do it, then I think we err. And so we may or may not disagree, but there is a very large area in which interpretation will allow us to take a First Amendment that has been abused by treating it as nothing more than an exercise in relativism, and treating it instead as an absolute constraint upon congressional power, without requiring us to forego the kinds of things, freedoms of association and rights of privacy, that have been added to it from time to time. Those are not internally inconsistent. But copyright actually is, insofar as the exclusivity right is concerned, on the face of it, inconsistent with an absolute First Amendment.
Take the absolute position that
Yeah,
copyright
yeah.
is
Well, I know that David has a plane to catch. I have a class to teach at 2:30. I want to thank everybody for coming. I hope you've enjoyed our program. If you have CLE forms, I think Galit is probably out there, and you can give those back to her. And we look forward to seeing you at the next JLJS and support events. Thank you.